Welcome to the Legally Speaking podcast. I'm your host, Rob Hanna. This week, I'm delighted to be joined by Ryan McCarl. Ryan is the founding partner of Rushing McCarl LLP, a business litigation firm based in California. He is an adjunct professor at Loyola Law School and was previously a fellow in artificial intelligence law and policy at UCLA School of Law. Ryan has experience as a clerk at the United States Courts of Appeal for the Tenth Circuit and as a litigation attorney at firms such as Wilmer Hale. Ryan also founded the educational technology startup Word Brewery. Ryan's book, Elegant Legal Writing, was published in 2014 February and has gained recognition from high-profile individuals in the legal profession. Ryan is passionate about legal writing, litigation strategies, and advocacy, having spoken at the American Bar Associate Litigation Section and the Texas Office of the Attorney General. So, a very big warm welcome, Ryan.
Good morning. Glad to be here.
It's a pleasure to have you, Ryan. And before we dive into all your amazing projects, experiences, and everything you've been getting up to for the legal community, we do have an icebreaker question here on the Legally Speaking podcast, which is, on the scale of 1 to 10, 10 being very real, what would you rate the hit TV series Suits in terms of its reality of the law if you've seen it?
I can't speak to it too much because I only watched about 5 minutes of one episode, and then it was enough. It was unrealistic or off-putting enough for me personally that I didn't want to continue.
Well, with that, I think you can give it a fair 0, and we should move swiftly on to talk all about you and your real legal career. So to begin with, would you mind telling our listeners a bit about your background and career journey?
Absolutely. So I'm currently a founding partner of Rushing McCarl LLP. We're a business litigation firm based in Los Angeles. I'm also the author of Elegant Legal Writing, which came out last month from the University of California Press. Before that, I've taught advanced legal writing courses at UCLA and Loyola. Studied AI, was an AI research fellow at UCLA as well. Clerked for Judge Ebell in the Tenth Circuit. Was a litigator at a couple different firms as well before going to UCLA. And before going to law school, I was a high school history teacher for a couple of years. So, and then somewhere along the way in there, I also founded a language learning ed tech startup called Word Brewery, which taught languages and high frequency vocabulary in about 20 different languages using real sentences from the news with the sentences tailored to the individual's current levels. So there's been a continuous thread or theme in all the work I've done. A couple of themes, one being a love of teaching and a love of writing. I also love litigating, but I don't really see those as being completely separate skills. My work as a litigator entails teaching the judge, like through my motions and briefs and oral arguments. I really see it as teaching the court, the judge, the legal rules and principles that will help them decide the case accurately and in my client's favor. And yeah, I see the same issue involved internally as I'm helping my team produce the best work product possible. So I never really take off the law professor and writing teacher hat for too long. So those different parts of my current career of teaching, writing, and practicing all fit pretty seamlessly into each other.
Yeah, and you just summed up some super impressive work in a very short space of time there. There's a lot that I want to unpack. I'd probably add one extra layer to that as well. It's tech, right? Almost like it advanced ahead of your time in terms of, well, certainly people, when they're talking about AI and language models and everything else and these innovative platforms that you've been involved in, I think there's clearly, a passion for tech in there as well, which fuses in nicely to everything that you're about. But let's go back to your clerk days, because you did have experience, as you say, for the United Courts of Appeal for the 10th Circuit. What was that like? Talk us through your experience there.
It was really a wonderful way to transition into practice because in that first year coming out of law school, I guess the ability to see behind the scenes and work closely with Judge Ebell and his chambers and work within his chambers and kind of get a sense of how judges operate and make decisions behind the scenes was incredibly enlightening. And the full payoff to that experience, I think, only became gradually clear over time as I got further along in my career and closer to the point where I was actually arguing in front of judges and controlling case strategy It's a little hard to see the forest for the trees a little bit when you're an associate at a big firm. But once you transition, or if you do transition to working in a smaller firm with a smaller practice group, as I did once I co-founded Rushing McCarl LLP with my partner John Rushing, and you're running litigation from the beginning, you're the one that's deciding on the arguments that are going to go into the motion, and writing the briefs personally and with your team. And I would say that having the understanding of how judges think, as well as kind of the lessons in professional, just the different aspects of being a legal professional before the bar, a sense of the dignity associated with it, all that stuff that I picked up for the first time in my work with Judge Bell turned out to be extremely helpful. I often share one anecdote from my clerking experience with my team, which I think is an important one for those of us who are kind of born to argue and love to argue. And that is that Judge Bell once told me that you have to listen as an advocate for a shift in the judge's tone from when they are entertaining what you have to say, and then at some point they'll reach a decision and shut out alternative possibilities. And you have to avoid annoying a judge, to make a judge respect you as an advocate because you're showing respect for the tribunal. It's important to listen carefully for when that shift occurs, and then stop arguing, essentially stop talking. And it's even little lessons like that turn out to be very useful over time, because they've allowed me to speak with judges in such a way, I guess, with a level of comfort, because I've worked closely with one for a year, but also in a way that is fully respectful of their office and that they appreciate.
And yeah, and that's such a great point as well. It just comes to mind, 2 ears, 1 mouth. And, I always talk about from my, initial sales training in terms of, tone, pace, volume, really listening out for those sort of subtle details, because details matter. So if you can get taught and pick up those little things along the way, you increasingly become that 1%, 2% better than other people that you're competing against. So thank you for sharing that story. Really interesting. Okay, so you've worked with some powerhouses along the way as well. You've been a litigation attorney for the likes of Wilmer Hale. What skills did you pick up that again have helped you as you've moved on to sort of founding your own firm at those types of firms?
I think part of what you learn in those first few years of practice, if you work at a big prestigious firm like that, hopefully in other environments as well, you learn from your colleagues. You learn what it means to be a lawyer, what it looks like day to day, the general habit of understanding the stakes of litigation, understanding the pace of litigation, and how you have to maybe adapt your previous work experiences or your habits as a student to the realities that a lot of your life is going to be controlled by the client's needs, by the court schedule, and so on. And I think one of the most important things that associates can do as they start their careers at a larger firm, when they don't have a whole lot of sometimes you're kind of put on large teams that you're not directly making decisions about the law, about legal strategy. You may just be, I guess helping people with pre-existing projects and helping people with, with writing that they've done, and you're just helping them execute it. It's important. I think one of the things you can get out of that time period is just to realize that you're very early on your growth curve as a litigator. It really is, no matter how smart you are or how well you did in law school, it really does require a major professional pivot, and you are starting really from scratch. You have the fundamental tools that you bring with you, but those are a lot less important and refined than they'll be in 5 or 6 years. And it's a blind spot for a lot of new attorneys, because you kind of assume that you did well in law school, you've done well your whole life, therefore this is just the next challenge, and it's not really that different from what comes before. And I don't agree with that. In my experience, practicing law is quite different from any other life experience I've had, and it requires a degree of self-discipline and resilience, and day-to-day confidence that takes a little bit of time to develop. And every task that you perform as a lawyer, every experience you have interacting with opposing counsel or taking a deposition, working with a client, it's like building a habit, building building calluses. I've heard one attorney describe it as, and everything you do, it's easier to do it again the next time, but it's different. It's hard to remember when you're a ways into your career exactly how little you knew at the beginning. And I think that the most important thing that new associates can do is to really try to learn and soak in knowledge, learn by observing the way your colleagues, your more experienced colleagues, go about their day, how they practice, what their thought processes are, what they think is important versus less important, how they prioritize, and be humble about the knowledge that you need to acquire and the skills you need to acquire to be able to represent clients at a high level.
Yeah, and again, it comes back to sort of things that I always tell people to think about when they're starting their careers. Is to almost like be curious and to be a sponge and try and soak up as much wisdom as you can. And it's by being in those environments you'll learn by osmosis, and you'll pick up those little things because by and large it's these little things, because the law is the law, and the way you practice the law and your technical skill sets, yes, they can vary to a degree, but these little things that you're discussing could potentially have a huge impact on how you win cases or how you get ahead of other people and become the top of your field. So you talked a lot about sort of confidence, resilience, a lot of these skills that are needed. I'm sure you've needed them through founding your own firm. People always see the headlines, don't they? They see a law firm, you're owning a firm, it must be fantastic, life is amazing, it's the easiest, best thing on the world. Talk us through your experience from founding, Ryan McCarl LLP, and you touched on the type of work you do, but just tell us a little bit more about what you specialize in.
Sure. Well, meeting my partner, John Rushing, was really one of the best things that's ever happened, if not the best thing that's ever happened in my own legal career, because co-founding a firm, starting a small firm, wasn't really on my radar until I met him. And John also has a background working at larger firms. He worked at Sidley Austin for 6 years or so, and he also, after that time, had developed experience working as a trial lawyer. Had a lot of success in that domain, and he'd also done a stint as an actor and producer in entertainment. And so John's kind of a larger than life character with this great charisma and this powerful way of communicating and speaking. He's a brilliant negotiator. He's a brilliant trial lawyer, brilliant advocate, and our general inclinations about what we like to do, what parts of the practice we enjoy, and what our skill sets are really fully complementary. So he's an extrovert who's happy being on the phone all day and arguing all day. I'm more of an introvert who likes to have the bulk of my day spent writing, reading, thinking, delegating, that kind of thing, soaking in, getting really deep into the weeds of a case so I can help guide strategy. And so it really everything's a really natural division of labor between us, and between kind of his oral advocacy skills and negotiation skills, client and working with client skills and administrative skills, and what I bring in terms of legal strategy and writing, and kind of managing a case, is it leads to a pretty powerful 1-2 punch for our clients. And so the fact that we both have backgrounds at top firms as well, I think makes us quite different from a lot of other boutiques, in that we set out at the beginning to kind of maintain the same standards we'd observed and practiced and been part of at the larger firms, and just practice them on a boutique scale. And I think that as a result, people underestimate other opposing counsel from large firms sometimes initially may underestimate us because we're 4 years old and we have a smaller team, but that's to their peril because we practice law at a very, very high level.
Yeah, and it's true, isn't it? I always say, boutique is beautiful, and, it's not always just about, being the absolute largest out there. Yes, like you say, you've acquired all this skill, all this experience, but just because you're in a different environment now doesn't think that you've lost that skill in any way. And actually, you probably enhanced yourself because there's more skills that you pick up along the way with that. So, yeah, and I like the fact that you talked about complementary skill sets as well. I think you don't want exactly replicas of the same people with the same skills within the firm, because you want want different opinions or different strengths in certain areas, because you can't all be strong in absolutely every area. So if you've got people in those really strong places, you can play them to their strengths. So you touched on it there in terms of what you enjoy doing and like where your strengths are, but talk us through like a typical day of a co-founder of a a law firm like yours. What do you get up to? What are some of the responsibilities as a partner?
Absolutely. So it's usually there's always going to be some thinking through intakes with John, meeting with prospective clients, meeting with current clients, and doing on the operations side. I've built building the firm's processes in terms of task tracking, calendaring, all these little details that are invisible to associates at big firms sometimes, because sometimes behind the scenes there's software, there's a whole armada of paralegals and legal secretaries. And when you start a firm as a small group, you have to sometimes build those type of operations from scratch. And you sort of at the beginning maybe live in constant fear of missing important deadlines and so on, or having something drop through the cracks. And so the solution is to build systems and training. Develop training programs and build systems and hire and then impress upon your team the importance of following the systems that are created, and then kind of making sure that they're followed day to day. So that helps you, I guess, once you have those systems in place and you trust them, and your team and everybody's kind of rowing in the same direction, then that frees you again to focus on getting wins and focus on the team. You realizing you're part of a team that you can trust. And now it's now that I know that if I focus on this one matter that's coming up, for where we are going to file a dispositive motion, or we have to make kind of a decisive choice about case strategy, or I'm arguing a key motion the next morning, you have to be able to set aside the concerns of the putting out one fire after another, answering one email after another, making sure that everybody is doing the right thing. You have to be able to set it aside to get the mental space to work on those projects, just as I often had to do when I was writing my book. You really can't make progress on any. It's very hard to make sustained progress in any kind of writing project, whether it's a big appellate brief or whether it's a book or an article or anything else, without being able to shut off distractions, both necessary distractions and unnecessary ones, to try to get into the flow and have all of your mental activity devoted to the one task for a certain block of time.
Yeah, I agree. Someone who's easily distracted, I'm very big on sort of, time blocking and being dedicated to a task and setting myself goals, because it's very easy to get sidetracked by one thing or another. And I'm looking forward to talking a bit more about your writing and your books in a moment. But I want to talk about some of your memorable cases, because you've been involved in several high value cases over the years, including securing $17.8 million federal jury verdict for a cosmetic manufacturer. So do you have any other sort of memorable cases or favorite cases that have stood out to you from over the years?
Well, I love, I don't want this to be a cop-out answer, but the great thing about starting your own firm and being part of a smaller group and one of the people in charge of it is that you can pick your clients and pick your cases. And John and I both, John has a master's from Oxford in scholastic philosophy. I have an amateur interest in philosophy. I love legal theory. I love, getting into the weeds on property law. I read books about prose style and linguistics for fun. And so we both have this sort of intellectual drive and curiosity, and it does shape the way we, came into the niche, settled on the niche of business law and business litigation. And it shapes how we pick cases to some degree, because neither of us like the way we practice. We really like to have a sense of intellectual curiosity about the case that's going to provide its own motivation. So passion for this particular client, passion for this particular matter. And we've realized that complex business litigation cases are the sort that really allows us to make the most of our skill set. Cases where there's going to be some good faith arguments on different sides of key issues, cases with a bit of factual intrigue, and that are going to require some interesting investigation. So we have one case. One of our earliest cases, which is still ongoing, is a dispute over a large cannabis business, and it's just an extremely complicated partnership dispute that raises fascinating practical and theoretical issues related to what happens when co-founders go into business together without a partnership agreement or any a kind of shareholders agreement or anything of the sort. They just start working together, and then they work together to build a business for 3.5 years, and then things start going off the rails. And trying to understand the law around that and develop it into a story that's ultimately going to be compelling at trial is a really fascinating process. And so there's quite a few cases like that where I've had the opportunity to. I used to have this misconception that you have to be an appellate lawyer or to do interesting legal work. It's just not true. And I like appellate and trial work and pretrial work really the same in each respect, because on every difficult case, most cases where it's clear as day, they settle very early or an insurer covers them. But most cases that once you get into the point where you have dispositive motions going back and forth, there's some kind of good faith core arguments on either side, and very rarely is there something that's so squarely on point that it just resolves it with no problem, so you can write a 1 or 2 page brief. Usually it takes more than that. And so anytime I get to make creative arguments, that's what I love about my work, and it's what I'm best at, and I get to do it every day. I get to do it a lot more often than I would have expected.
Yeah, and it's clear the passion just oozing from the way that you sort of articulate everything that you've sort of like doing and sort of your background, and it's great because that's what you want. You want to be passionate about what you're doing, and we've touched on it. We're going to talk more now about your legal writing, because obviously it is something you're passionate about. Your articles have been published in the Stanford Journal of International Law, Cincinnati Law Review, Real Estate Law Journal, just to name a few. Loads and loads and loads. So when did your journey writing for law journals start?
So I during the summer while I was studying for the bar exam, I got, I think, my first 3 or 4 law review articles accepted, including, I think, all the ones you just listed. And that is, I was considering becoming a law professor. I ultimately ended up becoming one, but as a part-time adjunct or for the couple-year fellowship I did on the faculty at UCLA. But I decided that the scholarship route was ultimately not for me, because I like competition too much. I'm a former high school track and cross country athlete, in college as well, and I love the competitive aspect of litigation, the way that provides sort of day to day the need to really be on your game day to day, because your opposing counsel's, you can't stand the thought that opposing counsel's working harder than you are, and just it's not tolerable to me. So I turned out to not really be interested in the pace of being a full-time academic scholarship. I instead like to have one foot in the world of, while I'm litigating full-time, to also be teaching a writing class, doing writing CLEs, and writing books and articles. So those articles, getting those published early was based on developing seminar papers I'd written in law school, and then working with academic mentors to flesh them out into full articles. That really set the stage for a good start to my legal career, because it's really hard to find time to do that kind of thing once you start. And, although most people spend their summers before taking the bar exam purely studying for the bar, I just am kind of constitutionally unable to do just that one thing for the whole summer. And I trusted that if I spent enough time studying for the bar, it would be enough, but that wouldn't require all day, every day. And so I was able to use some of that time to get kind of a head start on my career by publishing.
Yeah, no, and that's a great tip for people listening. Again, these little things that you can do that can have big impacts and skills along the way. You put in the time and dedicate the time, then, success comes along. So in 2024, February, your book did come out, Elegant Legal Writing, and was published by the University of California Press. Congratulations. What is the aim of the book, and what do you hope for readers to learn?
Sure. The book is about how to write briefs and other documents that judges or your other target reader actually want to read and are likely to read. Because when an important mindset shift you have to make in legal writing, and most professional writing for that matter, is that nobody is reading your brief because they choose to. They are reading it because it's a tool that they feel they must read in order to help them reach a decision. And when you shift your mindset to that, you realize that the judge actually, nobody's watching the judge, so there's no guarantee that they have to read your brief carefully or at all. And then you learn anecdotes about how busy judges are, especially at the trial court level. For example, I've spoken with a state court judge who said that they had a active docket of 1,200 civil cases. And even in the federal courts here in the Central District of California, I've heard of caseloads ranging from anywhere from 250 to 450 and upwards for the individual district court judges. That's really hard to even conceive of for me, as somebody who, we've adopted kind of a slow growth mentality at our firm, where we make sure we can fully execute on and do our best on a case before we take it, and we don't allow ourselves to get overwhelmed. We just pace the intakes such that, we take the cases that really are going to benefit the most from us, and then where we make sure we're going to really execute at a high level. And when you think about having a portfolio of cases of 500 or 1,200 as a judge, you start wondering how they possibly do that, and if there's a physical time. And that should lead you to the insight that judges don't have patience for long-winded, kind of blustering litigation filings. Your litigation filing has to be seen by the judge instantly as a helpful tool, a tool that will help them make a legally correct decision that's unlikely to get them reversed. And so with that in mind, from the beginning of the brief onward, you should be showing the judge that you're going to be helpful, getting straight to the point, leading with your best argument on page 1, and then thinking about the reader's attention span and motivation throughout the writing process to how are you going to get the judge's attention and keep them reading. So the book draws on a lot of insights from cognitive psychology, the idea of readability, narrative techniques from fiction writing, such as thinking about pacing and rhythm, and it's all about trying to get the judge's attention, write in a way that they're going to find persuasive and hold their interest throughout the duration of the brief.
Yeah, and it's fascinating. Today's episode is brought to you by Clio Payments, the ultimate solutions for law firms looking to streamline their billing and payments. Clio Payments, available in the UK, has updated its pricing for pay-by-bank transfers, allowing you to accept these transfers for free. Yes, that's right, 0 fees on bank transfers. And here's the cherry on top. Until May 31st, 2024, Clio is offering new customers an incredible 90 days of free card processing on card payments. With Clio Payments, which is included in Clio Managed subscriptions, you can handle all your billing, payments, and collections seamlessly right within the Clio platform. No more switching between systems, no more headaches, just pure efficiency. Record your time, generate and send bills, accept payments, and automate reminders and reconcile payments, all in one place. Even after the 90 days, you'll continue to enjoy free pay-by-bank transfers. As for card payments, they'll be charged at standard rates. Don't miss out on this incredible offer to save money and gain more time for what truly matters. Visit clio.com/UK/payments today to learn more and start simplifying your law firm billing and payments process. That's clio.com, clio.com/UK/payments. Offer ends 31st of May 2024. Terms and conditions apply. Now back to the show. I want to dive a bit more on the book, particularly as you mentioned, because there's a lot of detail in there, and it's a really good piece of information that I would highly encourage people to check out, because you also split the book into 3 parts. So style, substance, and process. So would you mind briefly explaining these 3 different parts and the topic you cover in each?
Sure. So the book, my notes for the book originated when I designed an advanced legal writing course at UCLA School of Law. And having taught 9th graders before going to law school, I've always been interested in this question of how do you get students to read, and how do you convey information as quickly and efficiently as possible, especially when you can't take the motivation of the student or the reader for granted. And so the books the first thing I did when I was researching for the book back in 2020 or so was to really read pretty voraciously all the books I could get my hands on about prose style generally and about legal writing specifically, and then think about what are the most important lessons out there, the most important kind of consensus principles about audience, about sentence structure, and so on, and then how can I distill them into very, very small bite-sized lessons, which are illustrated by real examples drawn from the sort of litigation filings that the students will be preparing. So I developed that curriculum. I gathered those examples, and the first part of the book, the part relating to style, really describes those core techniques, the core techniques for writing concisely, for how to structure sentences in a way that is friendly to the reader's working memory, how to organize a brief as a whole, what principles go into thinking through that part of it, and really, it's really about prose composition and mechanics for that first part. And that's the part of the book that's the heart of the book, and it's gotten the most attention. And what I've heard about it as it's gotten really great reception across the legal profession, both from students and professors and from practitioners. I've heard that people really appreciate the pace of the lessons and the fact that they're all illustrated by example. So I didn't go in assuming that people want to read about prose composition. I went in assuming the opposite. And so with that in mind, I try to get across a lesson or a point so quickly that it's inconceivable that somebody could get bored, because there's just there's so much information packed in as quickly as possible and as pleasantly to read as possible that you learn it and you're on to the next thing. So that's really on the substance or on the style side. On the substance side, I learned from grading students' papers and opposing and observing what I've and observing work done by myself earlier in my career, by opposing counsel, by people who work for us, observing where arguments sometimes fall off the track, or why something is less persuasive, why one way of talking about a legal precedent is less persuasive than another. And so I've always kept my notes on feedback I've given, and I've tried to distill principles about those as well. And I've sort of, in the substance part of the book, I really go straight to some of the things that cause the most trouble for students and attorneys, ways, and try to help provide actionable ways to address those. For example, I discuss what it means when your writing is conclusory, when you're expressing, you're expressing the way you want the judge to rule, or you're stating that a legal test applies or comes out, a legal analysis comes out a certain way, or that a previous case supports you, but you're not fully articulating the essential reasoning behind it. I help people identify that problem and show them how to fix it. I talk about the structure of legal authority, what cases to cite and how many to cite for each point, and then how to structure your arguments into ones that are going to be persuasive and gotten across as clearly and efficiently as possible. So the process part, I think that that writing is difficult. There's, especially for somebody that's written articles or a book, there may be a belief that it's easier for me than it is, or for any professional writer than in fact it is. I actually I think any professional writer, there's a reason that they talk about writer's block and resistance as often as so many do, because productivity and sustained focus work is very hard, especially in the digital age. So I think maybe one of the longer chapters in the book is called The Mental Game of Writing. And it really compresses in a short form the most important and non-obvious productivity tips that I've ever developed. That I've ever learned. Some of them I've developed, but mostly they're ones I've learned from elsewhere, and I've kind of gathered them and put my own spin on them. And we talked earlier. You mentioned time blocking. There's the concept of flow, of getting of getting in the state of work of writing such that it almost feels effortless because you're so immersed in the problem, and avoiding distractions. So I think I've gotten a lot of positive feedback on that chapter, and then also on the chapter on writing technology, which talks about sort of, again, non-obvious tips that a lot of lawyers, turns out, are not familiar with, such as using text expansion to quickly type a snippet of text and then produce an entire longer phrase or paragraph. To me, it always surprises me that other people are willing to type out a phrase like reasonable care or United States District Court every time, when I would just write some 3 or 4 character shortcut to produce that. And so that chapter, that part of the book, is really about introducing litigators to these things that they really should be doing to save themselves a lot of time. And it goes beyond. I don't have anything in there that I would consider to be kind of run-of-the-mill or standard advice that most people are familiar with. The selection principle was, it's going to be useful for a lot of practicing lawyers, and most practicing lawyers I know don't do it.
Yeah, and that leads nicely on to what I was going to ask next, actually, in terms of common pitfalls that you see when it comes to legal writing, especially regarding litigators, and how they can overcome these. What would you say to that?
Well, the first that comes to mind, of course, is just that we're still using legalese. We're still using very indirect and kind of convoluted ways of writing that I think are largely the result of path dependence, or the way that people learn by observing what their superiors did earlier in their career, the way that some judicial opinions are writing, the way opponents are writing, the way that the old form books that exist in Lexis and Westlaw and provide templates, the way those are written, the way contracts are written. And so there's a lot of writing practices, standard phrasings like each and every, any and all, terms and conditions, comes now before the court. These ritual phrases, these indirect ways of writing and talking that are they're almost like they're designed to make it seem like you're a lawyer, or and that you're part of this sort of professional in-group, but they're not intended. Nobody's ever really thought through, with people that are using them, haven't really thought through whether they serve the reader and whether they make the reading easy to read or not. And sometimes we use the habits invisibly, just because that's how we learned, that's what we've picked up over the course of our writing career. So, but I think for a long time, both in general prose style and also in the legal writing academic community, there's been a consensus in favor of abandoning legalese and writing in plain language. So the book talks about, provides specific tips about what that means and how to write concisely and write in a way that is reader oriented, and that is designed to convey your message as concisely and persuasively as possible, based on an assumption that the judge that's reading your brief is only going to be reading it if they find it helpful, and they're only going to be devoting the minimum possible energy that they need to, that they believe they need to get to grasp your argument. So I think what you find in most litigation briefs is a burying of the lead, is a lot of roundabout ways of talking within a sentence, within the whole document, repeating information on the cover that ultimately turn out to be, upon reflection, a distraction rather than a help to the judge.
Yeah, I always say it's better to be clear than it is to be clever sometimes, and it's very apparent that what you're teaching in terms of being concise. Of course, you need to make sure you're putting the right things in a concise manner in there. Is far better than these, say, like trying to be too around the houses and not getting to the point. Okay, I want to talk about sort of your views on next generation education, because you're currently an adjunct professor at Loyola Law School. How do you think law schools are adapting their curriculums, if they are, to prepare future lawyers for the increasing role of AI in the legal profession?
Oh, there's a lot of talk about it. I was just at a legal writing conference hosted by Loyola a few days ago, and anytime you go to an academic conference right now, there's a lot of presentations and discussions, and there's discussions on academic listservs, mailing lists, about how to teach about AI, how and whether to incorporate it into the curriculum. And I think there's a general consensus that it needs to be addressed or taught or talked about somehow. Maybe it should be to some extent. Maybe it should be taught expressly. Of course, there's a danger, to making it too big of a part of the 1L curriculum based on the current tools, which we're only in maybe year 2 of generative AI after the the GPT breakthrough. I think, and I personally believe, as somebody who's taught at different levels for many years, that that the biggest risk that it poses to students at every stage is that they may not the process of struggling through a problem, the process of thinking it through and then writing out an analysis is so fundamental to what you're going to do in your career and what you need to be able to do well to be a good lawyer. And the idea that that you can just delegate that process to a computer program of any kind, no matter how impressive, is just a recipe for it's a recipe for not being a good lawyer, because you don't have the judgment or the understanding if you've taken that shortcut too often for too long, you may not ever develop the legal judgment to be able to evaluate what the program is telling you and suggesting. I find lawyers, just even if they're kind of repeating something they saw in a case, but they haven't completely thought through the entire theory of that case and of that doctrine, that superficiality of that knowledge can be targeted by the opponent and undermined very, very effectively if the opponent is better prepared and has a deeper understanding. I mean, that's one of the things that we take pride in doing in our firm. And I think the AI, as impressive as it is and as useful of a tool as it is, I think it's super important to especially when you're in the learning stages, to work problems in their entirety without the help of asking a computer program to do it for you.
Yeah, and it just brings back to one of the tips that one of my mentors gave me very, very early on. He said, there's 3 things I'm going to teach you to do very well. And he said, it's prepare, prepare, and prepare. And it's so true, right? Because you're absolutely right. You need to ensure that you are 100% prepared, because the whole sort of, I guess, notion of this conversation is those little details that can really make a huge difference. And if you are just relying on a piece of technology and maybe it hasn't got into that level of depth that you truly understand, and like you say, opposing counsel picks that up, you could end up falling quite short. So, absolutely, I am all for tools and enabling the use of tools, but making sure that you understand and can make sure that you can really showcase your legal acumen and win cases is super important. Okay, so let's stick with AI briefly, because we're also a fellow in the Artificial Intelligence Law and Policy at the UCLA School of Law. As you research, no doubt, the use of artificial intelligence in the legal profession, how do you think the use of AI and technology will affect the legal industry in the long term?
I was a fellow just before the ChatGPT came out and the generative AI revolution occurred. So that was interesting to be kind of in the last studying it at a time at its current state back in 2019 through 2021, just before that great leap happened, because it really was a significant leap in the technology. It was really a dramatic improvement on everything that had come before. I think it's tempting for it to seem better than it is. I think the more you know about a topic, the more you are going to be skeptical of the responses, and realize that sometimes there's a level of superficiality or subtle misunderstandings that they reflect, that somebody with deep expertise can see and work around, but people who have only kind of a superficial understanding might not notice. I think I think that AI programs, the generative AI programs, are very useful, especially for getting a quick overview of something, of a topic, summarizing cases, finding information within a sea of documents, asking, finding research leads by asking kind of, I found that, for example, using Casetext's co-counsel AI memos as to do an initial pass to find cases where I can begin my research has been a very useful tool for me in the past year and a half. So I will often assign a research task to one of our associates or law clerks, and then at the same time as I assign it, I may develop a prompt and then run it through case text AI, and then send that to them as well. Or alternatively have them go forward with the research and then check it, and then kind of also run the prompt separately without sharing it to see, so it doesn't kind of prime them. But what it's useful for is useful for the fact that among the maybe 30 or 40 cases that it cites and provides brief excerpts or summaries from, there may be one or two that even if that could themselves be helpful, but more importantly, are going to be cases where you can find a starting point where they're talking about the rules. Because sometimes if you know that there's if you have an idea of an intuition of what the law surely must be to address a current situation, but you might not be familiar with the particular doctrine or the particular statute or the particular kind of line of cases or precedent, it's really finding that starting point that I think is the crucial step in the reasoning process, or I'm sorry, in the legal research process. And the AI tools are very helpful. CaseText in particular has been really helpful in finding that starting point. But what you do then is for me at least, I recommend that traditional research methods take over, and you put away the AI and you start reading cases, and you follow and you trace citation networks outward from their source, and think through to make sure you fully understand the doctrine. The obvious, quite embarrassing error that some attorneys seem to be making, as you can see all over LinkedIn and the news, is that they somehow think that running the AI at the beginning produces an output that you can go ahead and stick in front of a court. And really, it's not even close. I mean, the hard limitation that I see in the use of AI in the legal profession for practicing lawyers is that everything, because of our duty of competence and our duty of candor to the tribunal, and the habit of being detail oriented with respect to your client's rights when they have so much at stake, requires us to do more than have superficial knowledge. It requires us to do more than than turn in some boilerplate form downloaded from Lexis, or have AI do 60% of the work of writing a brief. You just can't do it, because the whole the reason that lawyers are needed, the reason that good lawyers are good, is that they've filtered all that information that's been available, whether through traditional means or through AI, through their expert human judgment, and then ensure it's correct, and then tailored it, crafted it into a coherent argument, and then tailored it into a package that is going to be persuasive and informative.
Yeah, and I think you've given a very strong case for humans are not going to AI is not going to be replacing lawyers anytime soon. And I think you gave some really solid examples around that, but also how it can be utilized as an effective tool. But you also mentioned, of course, check, and don't just put something out there without going through that level of thorough detail. This has been awesome. I've really enjoyed Ryan, learning more about your career, your writing, your books, everything you've been getting up to. I want to ask one final piece of advice for the next generation of lawyers. What would be your advice for those at the beginning of their legal careers and they're looking to specifically, really improve their legal writing skills to stand out?
Yeah, so at the beginning of Elegant Legal Writing, I addressed this quite directly, ways to improve your writing over time. I think first that you have to adopt a growth mindset and understand that all the different ingredients of good writing they're not matters of talent, they're matters of skill and technique, and we all can improve our writing over time. It's like learning an instrument. It's not, it's okay if maybe you don't learn. I don't think not learning how to write well is a very good option for lawyers, because it's 90% of our job is written advocacy and explanations. So but if you see that and you understand that it's valuable to improve your writing, I think it's then worth understanding that, as with learning an instrument, as somebody a lifelong learner of an instrument, you can always get better no matter how good you already are. So, the briefs, we're very proud of the filings we turn in. We think that they put us at the top of the market, but we still have mistakes that are inherent in the speed of litigation and the reality that you only have a certain amount of time to spend on work product and the fact that you're constantly growing and learning to catch those and learning to improve. And I think that the way people can improve, you have to put yourself in the mindset of constantly learning. You have to then think about, learning the techniques and that have been developed and the craft points that have been developed by reading a book like mine. It can also be helpful to read. There's other books that I recommend in the book itself. There's CLEs, writing coaches, and so on. Inviting feedback, hiring outside editors and coaches, and hiring experts to talk to your firm to elevate the firm's practices as a whole. Taking advantage of software like Ross Gruberman's Briefcatch or Grammarly to help with some of the line editing and polishing. There's so many things you can do to become a better writer, but it really to me boils down fundamentally to reading a lot of good prose and then learning about craft by and the purpose of my book fundamentally was to convey what I think are the most important parts of that point as efficiently as possible in a way that lawyers would like to read.
Yeah, no, absolutely. And I would encourage people to definitely check it out. And on that, if people want to learn more about your career journey or indeed your firm or the book, Elegant Legal Writing, where can they go to find out more? Feel free to shout out any websites, any social media handles. We'll also share them with this episode for you too.
Absolutely. So the book's on Amazon. And I also have a legal writing blog called Elegant Legal Writing. It's elegantlegalwriting.com. And with respect to social media, I'm active on LinkedIn, encouraging you listeners to reach out and follow that or connect with me. And then, the firm is Rushing McCarl LLP, and it's rushingmccarl.com. And we are, we're very proud of the work we do. And all the written work product is supervised by me and reflects, it reflects one way or the other the lessons that so many people have found valuable and praised the book for is what we try to implement day to day in our practice. And I think as a result, the way we practice turns out to be at a very high level and gives our clients the best possible chance of success.
Absolutely. And I love that. You really are looking after your people, your clients, and everything in between. So, Ryan, thank you so much. It's been an absolute pleasure having you on the show. Wishing you lots of continued success with your career. But from all of us on the Legally Speaking podcast, over and out. Thank you for listening to this week's episode. If you like the content here, why not check out our world-leading content and collaboration hub, the Legally Speaking Club, over on Discord. Go to our website, www.legallyspeakingpodcast.com, for the link to join our community there. Over and out.